Hey guys, Darrell Brooks is fighting his sovereign war on multiple fronts now. He imagines a world where you can just steal, beat, injure, assault, and murder people and face no consequences. But the small problem with that fantasy is something called reality. Oops. Well, while he's boning up on grounds and subject matter jurisdiction and the fine etiquette of flag fringe for the cases he's got coming up for trial, he might want to save some candle for no merit reports, because he might face that issue on his appeal in the parade massacre case. Michael Covey is the attorney who's been assigned to the case, and he was immediately assailed by people who know nothing about him, but who apparently think the system should have no checks and balances on a trial. Ultra government trusters, I suppose. But I take a glance at Covey's record, and it doesn't fit the simple idea of all I like is good and everything else is bad. Let's take a look at a couple of cases he's recently dealt with. What's this? A no merit report? What's this? Another no merit report? Wow. Could it be Covey takes his professional obligations seriously and only prosecutes appeals that meet the standards he's supposed to follow? Man, it looks like it. So recall, an appellate attorney can file a no merit report. I went over that in a different video. I'll link at the end where I explain how it works and the options the defendant has, and that does not include just getting another state-paid attorney. But let's look at one of the reports Covey did that was reviewed by the court. The appellate court considers the no merit report and conducts an independent review, and that happened here. So they say Covey analyzed the record, which he did, and concluded there was evidence at trial that was sufficient to support the guilty verdict. That doesn't mean the jury couldn't have come back with not guilty. It just says there was evidence in the trial level sufficient to support the verdict. The court agreed and therefore said there'd be no merit to a claim that the evidence was generally insufficient. Remember, the Court of Appeals doesn't set up there some new jury hearing witnesses or overruling the credibility determinations of the basic jury. They're there for legal errors primarily. Covey also analyzed the record as to the sentence imposed. The trial court considered various factors, which it's supposed to do, and had discretion in the sentence, so that's that. Covey also canvassed the entire record and considered whether there were other potential issues that would be worthy of appeal. He didn't find any, nor did the Court of Appeals, and this was a case where somebody was shooting someone else. So the Court of Appeals therefore affirmed the judgment and relieved Covey of further representation obligations. So we don't know what Covey will think when he completes the review of Brooks' trial. It was kind of complicated, largely due to Brooks' behavior and his sentencing. What we can see, however, that he's clearly not someone who just prosecutes any appeal that comes his way for a buck. Those who saw that in him without knowing anything about him, well, you're probably just seeing a reflection of yourself in the mirror. And this should worry Brooks, because integrity and Brooks are like oil and water. They don't mix. If Covey doesn't see a legal basis for appeal, it'll be back on Brooks, the lone sovereign, to handle his losing case. That's it. Thanks. Bye.